On issue number 7, I believe it's been adequately dealt with by the IEBC and its chairman. I will address you on only issue number 8, and I will try and avoid rehashing what the IEBC and its chairman addressed you, in my humble view, very effectively. This is simply looking at the test that has to be met by the petitioners in order to determine whether the election should be nullified. And you've settled this as far back as 2013 in Raila petition number 1, or it was petition number 5 actually, but it was the first election petition under the new constitutional dispensation, and repeated this in 2017. The long and short of it is that the question you must ask is whether it has been demonstrated that the election was conducted so badly that it was not substantially in accordance with the law relating to elections, in this case the Elections Act and Articles 81 and 86. The burden is squarely on the petitioners to demonstrate indeed this is the case. The word used by Section 83 is magnitude, of such magnitude, really. It is not enough to demonstrate there were irregularities. It is not enough to show that there was a breach of the law. But it has to go beyond that to show that it affected the outcome. Has that been done? I'm not going to take you through the multiple allegations of irregularities and breaches of the law. But I've tried to look at these petitions, the 7 surviving ones, and I think there are approximately 46 allegations of breaches of the law and irregularities. This is a classic case of throwing everything other than the kitchen sink at your opponent. There are a lot of overlaps, but by and large, everything that could be said has been said. And I'll come back to this. The kitchen sink did show up a little later. But I don't want to walk you through all of these allegations. Let's just look at a few of these. It's alleged that there has been an infiltration of the IEBC system. I'm not going to rehash what Mr. Mahatomane so well explained to you. But I think these petitions are an invitation to this court to lay down the law. It's one of your jobs. That it's not enough to show up here and throw things out there and say, we hope some of it will stick. No. People must be held to account. They must be told, show us where the evidence is. And indeed, this is what Rule 9 of the Supreme Court Presidential Election Rules requires, that when a petitioner presents a petition, they will also furnish evidence. Has that been done in my humble submission? No. This evidence of infiltration, in the first instance, was put in various affidavits. John Mark Githongo, you've been told about how he recanted this. There were allegations in various other affidavits. And what happened then? There was a robust response from the referee, the IEBC, and the first respondent. And then what do we have? We have a second burst of alleged evidence in the nature of an affidavit by George Njoroge. And we are not even, we did want to start playing games by saying this evidence should have come at the start, as the rules require. So this case keeps being panel beaten as we move along. And it's not just petition number 5 where this happens. it has happened in another petition where you were addressed about 291 constituencies and not 290. I believe there was a question from a judge directed at this, because there's a short answer to that, but the question was not directed at me. But that wasn't even pleaded. So what we have is a situation where you keep being told new things as we move along. There's another allegation that the IEBC was so dysfunctional that you couldn't possibly have an election that complies with the dictates of Article 86. And we are told that this started even before. Now the question is, why wasn't a challenge made to the mandate or to this institution before the elections? An Article 140 petition is very narrow. It concerns the results and nothing more. This petition has been turned, or these petitions, by many of the petitions, has been converted into an attack on the second, on the chairman or the chairperson of the IEBC. It's not the function of the court to look at the conduct of the chairperson with a view to taking action. You were addressed in great detail as to why or how he has affected the last 2-3 elections. So what were we waiting for when Article 251 tells us what to do? The Leadership and the Integrity Act tells us what to do. Let me very quickly, without going into any more of these 46 alleged irregularities and breaches of the law, just try and illustrate just how bad these petitions are, or how lacking in substance they are. And I will, Mr. Mahat Somane, my land friend, Mr. Mahat Somane, has spoken to this, but I want to illustrate by showing you just a little bit about what was contained in the affidavit of Arnold Ochieng Odinga. And if I could just, if it could be put up, I want us to look at what has been presented before this court. And it's quite easy to come to this court and say, listen, somewhere between the people expressing their will and the declaration of the results, there's been some tampering. Let's look at what they say. Paragraphs 81 to 91 of the affidavit of Arnold Ochieng Odinga says that there was willful, deliberate, and criminal tampering of certain results, and they've identified 41 forms. What I suspect they did not expect to happen is that the IEBC would respond to just about each and every one of these forms. Let's look at just one sample. And before we do that, what are we trying to achieve? We'll look at a Form 34A from the IEBC portal. We will look at Form 34A delivered by IEBC to the court. We will look at an affidavit from a presiding officer. And we'll look at an affidavit from an Azimio agent. And we'll look at a Form 34A provided by a UDA agent. The affidavit of the IEBC presiding officer is not part of the slides, but we will be able to compare these documents. If we could skip this next slide so that we move quickly. Let's skip that slide, please. Now the question is where the petitioners fraudulent 34, where allegedly fraudulent 34A came from. And I'll return to that at the end. Let's just look at Kibagare polling station. The next slide, please. If you look at the signatures, one of the signatures is an ODM agent, Mr. Eric Atuma. Now the petitioner in petition number 5 has filed many affidavits in response to the respondents, including the first respondent, they have not responded to this. They have not challenged this. But they put it out there as an illustration of what games were played either by the referee or in concert with the first respondent. So the first thing you note is the signatures of the two agents. The next thing I'd invite you to look at is what the votes were according to the IEBC portal. And Malanfem Mahat Somane invited you. The portal is up and running. Check this. What was the total of votes cast, or what was for the two candidates in Kibagare polling station, stream 2 of 7? Raila Amolo Odinga, 244. Mr. William Samoei Ruto, 114. Let's go to the next slide. If you look at the affidavit of the presiding officer, he's produced a similar form 34A. It says it gives the same outcome. The next slide. The UDA agent, same 244 and 114. Then you have the next slide, the Azimio agent, again, 224, 114. The next slide is the affidavit of their own agent. He says, what is in Mr. Odinga's affidavit is not what I submitted to the party. They decide, we're not going to respond to that. But we expect the court somehow to determine that there were fraudulent Form 34As. Is this right? Let's go to the next slide. What is in Mr. Odinga's affidavit? Look at the last column. It says, for Raila Amolo Odinga, 244 votes. For Mr. William Samoei Ruto, 38. What happened to the other votes? Something is fundamentally wrong. And this is just one document. We have filed other affidavits which illustrate what happened here. Let's look at the next slide. The law requires the IEBC to deliver certain forms. I'd invite the court to look at the form for this particular location, this particular polling station, and see whether what has been set out in Mr. Odinga's affidavit is correct. Let's go to the last slide. What then are we telling you? The numbers between the IEBC portal, the IEBC presiding officer, the UDA agent, the Azimio agent, and the Form 34A from Bomas are all aligned. Question we must ask is, where did the form that is presented by Mr. Odinga come from? Arnold Odinga, so that we do not mix up names. I think this must be what the late Issa Juma of Supawanyika had in mind when he penned the words, sisi twajua anafanya biashara, lakini biashara anajua mwenyewe. Only Mr. Odinga can tell us where this came from. And the other 40, they are not part of what was actually the product of the people expressing their will. So, in a nutshell, even without trying to demonstrate to you how the other irregularities and alleged infringements of the law have not affected the law, the petitioners fall far short of what is expected. But let me look at one or two things, because one of the things that has really featured a lot, and I'm going to try and avoid rehashing what has been said by the other lawyers, is that the commissioners have a significant role, that what 138(3)(c) means is that the commissioners, the 7 men and women, have to be involved in the exercise that is to be undertaken. With respect, this submission is skewed by a failure to interpret the Constitution correctly. I think it's long been settled that the Constitution, the interpretation of the Constitution, looks both at the text and the context. And what has happened here is that the petitioners have decided we will stick with the text. And even that they stretch. They say the IBC, the commission, means there's 7 of them. With respect, that's an invitation to the Supreme Court to, through the back door, overturn what Minor Kiai said, which is that you start at the lowest level and cascade things, but it is not the job of 7 men and women. Let's look at the 7 commissioners a little more, and in particular the 4 who it is said should lead to the conclusion that the election was not conducted in accordance with the Constitution. They were on board with every other commissioner. They spoke with one voice until about 3 p.m. on the 15th of August. Then they had their Damascus moment and made it to Serena. They changed their position. If you look at the affidavit of Samuel Gidai, look at the clips of the 4 commissioners announcing the results. But you were told here yesterday they were being given pieces of paper to read out numbers. Is this believable? But we were told by another speaker, another advocate, that these men and women were vetted by the National Assembly. They are therefore very serious citizens who correctly undertake a very important function, the running of elections. But they say they did not participate in this. In determining who to believe, look at the context. Look at the whole series of events from when the nomination took place, when the ballot papers were printed, including the supervision that they undertook, and determine whether these 4 commissioners are to be believed. Mr. Njenga, for I think the 7th respondent, argues they are here not to support either side, but to discharge their duty under the Constitution. But they did file a response. They started off by filing affidavits to set out the evidence. There's no property in a witness. They didn't stop there. On the 26th of August, they decided we will appoint another lawyer on behalf of the IBC who is in effect going to admit the alleged infringements. This is where you apply the duck test. If it looks like a duck, if it swims like a duck, if it quacks like a duck, it must be a duck. They are saying we are here to show you we are independent. Are they? With respect, their conduct demonstrates otherwise. In a word, it is my humble submission that the petitioners have not demonstrated there were any irregularities or illegalities. Forget the magnitude. They really haven't demonstrated any. I'd urge you to dismiss these petitions. Ordinarily in these sort of cases, and I'm not telling you what to do one way or the other, because of the nature of the matters, the parties are asked to bear their own costs. But again, what happens in 5 years if people can come in 8 petitions, 1 was struck out, and say whatever they wish to say without offering evidence? I think there was some advocate who said yesterday we're going to have 200 petitions in 5 years. Why? Because there are no consequences. We can all come here and be on television. There are no consequences. So what are we asking of you? We are asking you to give us back our country. Determine that there were no infringements, that we had a proper election. We have been in election mode for so long. The only thing that creates wealth is actually working. And this is not work. With respect, the tens of thousands, men and women who preside over elections are teachers and farmers and artisans and you name it. We're being asked to make them come back to work in a few months, or in 60 days to be precise. There is no justification for that. The order that should commend itself to you is to dismiss these petitions because they fall far short of what is required. Those are my submissions. Mr. Kioko Kilukumi will now address you on the 9th issue.